and Federal Aviation Administration. Mr. Straw for the petitioner, proposed contract change and inefficiencies. Mr. Meekin for the petitioner, ductwork issues. Ms. Nyosi for the respondents.
Good morning, counsel.
Good morning, Your Honor.
You may proceed.
Thank you, Your Honor. Good morning again, and may it please the court. My name is John Straw for petitioner Archer Western. I and my co-counsel, Mr. Meekin, will be addressing the three main issues in this appeal. I will take care of the two timeliness issues of proposed change 16 and disruptions, and Mr. Meekin will then address the ductwork issue.
So let's talk about your definition of accrue.
Thank you, Your Honor. A claim accrual requires that all events that fix liability must have occurred and permit assertion of a claim. That's under 14 CFR 17.27. Here, those events didn't occur until at the earliest there was a duty to perform the changed work, which happened April 3rd, 2013. At the latest, they accrued when the FAA failed to agree to the request for equitable adjustment. That was December of 2014.
So what about on February 7th, when your client submitted to the administration an estimate of costs and delays stemming from proposed contract change 16?
Thank you, Your Honor. So as of February 7th, the damages were capable of reasonable estimation, but not all of the events had yet occurred. The event that had yet to occur was an actual direction to do that work. The submission of the—
What I'm trying to understand is your client knew what or at least he told the administration, what the estimate of costs was going to be and the delay to completion of the contract. Why didn't he have full knowledge at that point?
He didn't, Your Honor, because there was no written directive to do the work yet, and that's similar to an ODRA case in 2013 of LNN MKB joint venture. There, the ODRA said that no claim accrued until there was a written order to actually do the work. In fact, they denied the contractor's motion for summary judgment in that case because even though there was forward pricing like there was here, there was yet to be a written directive to do that work. Similarly, the case of Jensen, which is a General Services Board of Contract Appeals decision. In that case, before there was a written order to apply a third coat of paint, the court said that it was as if there was no agreement, there was no contract to actually perform that extra work. The written order was required, and here it didn't happen until the earliest on April 3rd. In fact, the FAA knew that it hadn't happened yet because a couple of days before that, the FAA chief engineer, Mr. Brinker, emailed the contracting officer and said, "We know Archer Western is waiting on this order to do this work. Please tell them to do it." That order came then on April 3rd. There are a couple of cases that the FAA has asserted in its briefing that I'd like to address, one of which is the case of Electric Boat decided by the Federal Circuit just last year. In that case, the claim accrued when OSHA changed the regulation, but in that case, the parties had agreed that all it took was that one event to create the liability. It was a pre-agreed condition, kind of like the ASFA case, which is an ASBCA case where when the deadline passed to complete the project on time, liquidated damages immediately accrued. The parties agreed that all it took was passing that deadline in ASFA. In Zaffer, upon which the FAA also relies, the Court of Federal Claims held that at the point at which the delays began, the claim did accrue, but at that same time, there was already an obligation to perform the delayed work. Here, there was no obligation to perform the proposed change 16, item 10, until there was a written order, and that didn't happen, or that happened within 2 years of Archer Western filing its notice of contract dispute. It's, Your Honors, if I may,
Mr. Straw, what about the equitable adjustment argument? I actually thought of your two arguments with regard to claim number one. I thought that was the stronger of the two. Can you kind of spell that out a little bit?
Certainly, Your Honor. Thank you. And under the terms of the contract, when there was a, quote, failure to agree, end of quote, then a contract dispute could be filed. It had arisen at that point. That didn't happen until December 2014 when the FAA finally rejected the REA and issued the unilateral contract change. The FAA has now argued that the request for equitable adjustment process simply lengthens the negotiation period, and they have cited to a few cases to support that, one of which is CEMS, which is a Court of Federal Claims decision. In that case, the court said, quote, contractors' performance requirements must be enlarged, and the additional work results from a direction of the contracting officer. A dispute didn't arise until there was a failure to agree. In fact,
do you think that you could have gone to the ODRA with regard to the delay at issue in claim number 1? Do you think you could have gone to the ODRA before the equitable adjustment was denied?
I think we could have, but I don't think we had to at that point. Although we had a written order, the contract directed Archer Western to follow the changes process. In other words, why would you escalate it to the ODRA before you had to? In fact, when there was a direction on April 3rd, 2013 to do the work, the contracting officer in that same letter said, if you disagree, go follow the changes process and file a request for equitable adjustment. With some of the time that I have remaining, if I could turn to the disruptions argument, unless there's any other questions with respect to the first claim accrual argument. So with respect to disruptions, the ODRA arbitrarily ignored some of the additional supplemental information that was provided with the notice of contract dispute, which spells out the disruption claims in significant detail over several thousand pages. But even before all of that, the notice of contract dispute itself, especially with respect to proposed change 16, referenced specific impacts there. And in Exhibit 13 attached there too, talks about cumulative impacts. So the ODRA arbitrarily did not pay sufficient attention to both the substance and the same operative facts in the notices of contract dispute and relied more upon form. They didn't look at the exhibits attached there too as well with sufficient detail, which is similar to the Martin Resnick case, another ODRA case.
Mr. Straw, under which count of the initial notices do you say that you intended to bring the cumulative impact claim?
The cumulative impact claim arises from all the facts from all the counts. The very nature of that claim is retrospective and comprised of all the various changes and issues that arose on the project. So it's not one.
I thought there's something in the rules that says you have to specify each legal claim. Now, you don't have to use magic words. I agree with you about that. But to say that the cumulative impact was kind of, emanating from all of the counts seems very inconsistent with the requirement that when you go to the ODRA, you list each individual claim.
So thank you for that question, Your Honor. I would like to address it. However, I'm into my rebuttal time. If I may I address this and still keep my 3 minutes for rebuttal?
Well, let's see how it goes. Why don't you answer the judge's question?
Thank you, Your Honor. So with respect to Your Honor's question, the case of Alberici, which is an ASBCA case, said that you can decide and appeal and have jurisdiction to do so under a different legal theory, even if that specific legal theory isn't articulated, as long as the same operative facts supporting that theory are pled throughout the complaint or throughout the notice of appeal. It's also similar to the case of Placeway Construction, which is a Federal Circuit decision.
But I didn't read either of those cases to say that on appeal, you can argue a new theory based on an analysis of facts that you didn't offer. In other words, just saying, 1, 2, 3, 4, 5, these are separate claims. There was disruption. That's not enough.
So, Your Honor, I believe it is, and I believe under these cases it is, to the extent that you have to consider all the same operative facts. The Placeway case said that where form was given more weight over the substantive facts, the Lower court was actually reversed because they were focusing too much on form. Here, not only were there specific impacts alleged in the notice of contract dispute, but the supplemental information that was provided as a part of the dispute file laid out all cumulative impacts, which is similar to the Resnick case, an ODRA case. And with that, Your Honors, I'm approaching my time.
All right, thank you, counsel. We'll hear from co-counsel.
Yes, Your Honor. Thank you for your time today. My name again is Stephen Meekum, and I'm addressing the duct issue. As set forth in our briefs, the government has the burden of proof to show that the contractor did not comply with the specifications. ODRA did not find that the ductwork did not comply with the specifications. Rather, the ODRA found that the risk of future delamination was reasonable. In other words, at the time that it was rejected, there was no delamination. The ductwork complied with the specifications. The specification admittedly had a very low threshold, but the specifications indicated that all that it had to do was line the duct.
Well, let me just be clear about that. I thought your argument was more, and let me be clear, you didn't say it this way, but there has to be some expert evidence on this, doesn't there, for the government to meet its burden of proof? I mean, the government brief reads like, well, everybody knows it's the same manufacturer, et cetera. But that's not what the requirement is it?
No, the requirement is solely that it adhere to the liner of the duct.
Right, but my point is, how do you prove that?
How do you prove it?
Doesn't the agency need to proffer some expert testimony that a reasonable interpretation of the contract term is that this is what was contemplated and it wasn't done here?
I don't believe that that's what the expert testified about.
Well, do you agree expert testimony is necessary?
I do not agree that expert testimony is necessary.
Really?
And the reason why
if the agency says, well, we've been around here for a long time, we've seen a lot of cases, and it's our view that there's a problem here, that's enough?
I do not believe that is enough, Your Honor.
Well, what more would be required if you don't need expert testimony?
I believe what you have is the standard that's set forth in the specifications, and what the Gallagher Kaiser and what Archer Western did is they put the system to work. They doubled the speeds of the fans. So the velocities within the ductwork were twice what was the design specification. They ran that ductwork, they ran those velocities, that high velocity purge, for over 3 months, and not a single square inch of ductwork delaminated.
So these are friendly questions, although you're treating them as hostile questions. But in any event, have the courts held that OPRA itself is an expert as far as determining contract compliance?
Well, I believe that
and you don't need expert testimony. If that's true, then I wondered why the agency, as well as the contractor, offered expert testimony if they didn't need it.
Well, because we were offering testimony to say that it complied. And in fact, our expert specifically said that there was no standard set forth in the specifications.
So, sorry, the first part of my question, have courts held that OPRA itself is an expert?
Not that I'm aware of, no.
All right, so how do they prove the contract says do X, and your client says we did X in accordance with the contract terms, and the agency offers evidence that there's a problem here? Doesn't it have to offer that evidence through expert testimony?
The evidence that was offered through expert testimony was in relationship to there was no expert testimony by either party that said that the ductwork was non-compliant.
That's my point, counsel.
That's exactly right.
You need expert testimony. It's not enough for the agency to have a hunch.
Well, arguably so, but still,
I mean,
I
arguably
think
so.
if you look at the information provided by the FAA during the course of the project, the FAA said they were reviewing the ASTM documents and standards or testing, and they said, wait, that's not part of our specification. The reason for rejection should be the flaking from the ductwork, which was occurring on the round duct. It was not occurring on the rectangular duct. So from our perspective, in order to comply with the specifications, we look at what the specifications say and does it comply with that specification? And
so
there was no testimony.
Who told the agency there was a flaking issue as to the round ductwork?
It was flaking once they started the system.
Who told the agency that? Was it not through expert analysis and expert testimony?
No, it was not. What was happening?
Well, who are these people who are identified in the record as experts who testified that they tested this and they saw the flaking and this was going to be a problem down the road?
Those weren't experts, Your Honor. They were people within the organization that saw flakes coming out of the ductwork.
All right, so I understand that point, but who said that's a problem? Maybe that's the way it's supposed to operate.
Because the specifications say that the ductwork has to be lined with the duct.
I think you're missing my point here.
Okay.
Yes, the ductwork has to be lined. The contract itself, as I read it, doesn't say anything about, and the coating shall not flake. Is that correct?
That is correct.
So where is the evidence that flaking means that the coating does not comply with the contract specifications?
Because when the coating flakes off, there is no longer a lining on the duct.
Where is that evidence coming from?
The evidence is from observation, visual observations.
Yes, but counsel, we're in an area where normally it's not enough for, a man on the street to come in and say, oh, I see it's flaking. It must not be operating properly.
Well, Your Honor, if you were to look inside the ductwork and you were to see that there was no liner there because it had flaked off, then you would know.
Suppose hypothetically, it's the type of liner that you put on, it dries, and then when it's functioning properly, it flakes. And then down the road, as time passes, all the flaking occurs and there's no liner left, but that's what's contemplated.
Well, I guess that's an interpretation of the specifications.
No, this is a hypothetical.
I understand that, Your Honor. But again, my position would be that
so just put the man on the street who says, gee, it's flaking. That can't be the law. And I don't understand the record to even suggest that. Rather, these experts came in to say, this shouldn't be happening.
Counsel, do you acknowledge that evidence of delamination doesn't satisfy the contract requirements, right? I mean, I thought the evidence was coming from ASTM testing, which was showing that there was a failure of adhesion. And that is, if that is correct, there isn't any doubt that you failed to satisfy the contract.
Okay.
You can't have a failure of adhesion in this kind of work and say you satisfied the contract, right?
Well, Your Honor, I disagree with that because.
Oh, no, wait. Go with my question. I'm afraid you're about to ask something. You cannot have a failure of adhesion and say you satisfied the contract, right? And when ASTM testing shows there's a failure of adhesion, let's assume that's what the AST testing shows. That can't satisfy the contract requirements, right?
Yes, it can, Your Honor, because the ASTM standard, the ASTM 539 test applied a pressure over 1,000 times greater than what would be in the ductwork.
All right, forget the ASTM testing. You can't have a failure of adhesion and satisfy the contract, can you?
That is correct. And so the ductwork, the rectangular ductwork, didn't have an adhesion failure. It withstood double the velocities.
Back to Judge Edwards' question. How do we know that?
How do we know that? Because
Yes.
it was observed. If you look
I
at
gave you a hypothetical, counsel, that this is the type of coating that you put it on, you leave it there for, I don't know, a month, and then it's supposed to flake and it's supposed to disappear because there's been this chemical reaction that's gone on, and that's sufficient.
because that isn't.
I don't know why you're fighting.
Well, it's just that it's not what's called out in the specifications, Your Honor. That's all I'm saying. Is that that's not what's called.
Well, the specifications say we want a coating.
That's correct.
Period.
Period. And that's what
Now, it doesn't tell you what kind of coating. It doesn't tell you whether it's supposed to flake or not. Is it a coating that disappears after 6 months because it's supposed to?
It says it's a coating that's supposed to line the ductwork. So
For how long? For what time? It depends on the nature of the coating, doesn't it? And what its properties are and how those properties are supposed to exist. And doesn't somebody have to tell the agency, if the agency itself is not the expert, that having flaking coating is not consistent with the contract specification, given the nature of the coating, the nature of the vents, and what the coating, what the contract specification must have intended. Doesn't somebody have to say that to the agency?
I think that that certainly that would bolster the argument of either the agency or the contractor.
All right, so you think it's enough that it was flaking, period, and that's the end of the story.
Again, the rectangular duct was not flaking, and to me,
you're saying that evidence of flaking showed failure, and that's what the agency found as to the round.
Yes.
All right. And now the agency argues, well, manufactured by the same party, you know, we didn't expect this, blah, blah, blah.
Right.
I'm saying, is that enough?
Absolutely not.
Because
it wasn't flaking. It was complying with the specification.
How do we know that flaking is inconsistent with the specifications? We need expert testimony.
Well,
and as Judge Edwards' question was premised on, there was testing. All right. You had these people who were familiar with the nature of the coating and what was required by the specification.
Yes, and those experts testified that it was compliant with. And even the government's expert, after looking at all the evidence at the trial during the hearing, agreed that their initial assessment was incorrect and that it was premature and wrong to reject the rectangular duct.
So bottom line, they needed expert testimony. They didn't have it as to the rectangular ducts.
I would agree with that.
Mr. Meacham, can I ask one hypothetical and one fact question? The hypothetical is this. If the rectangular ducts had been flaking, would you agree that you failed to satisfy the contract?
I believe that if in those locations where it had failed, then it should have been replaced. Given the minimal amount of that.
Mr. Meacham, you said failed, but you might have meant flaked.
Flaked.
Okay, so in locations where, if there had been places where the rectangular ducts had been flaking, you would acknowledge that that was a failure of the contract, correct?
At those locations, not a wholesale replacement.
Okay, yes, at those locations, right?
Yes.
Okay, and this is the fact question. Are the turning vanes part of the rectangular ducts?
They are an appurtenance that are located inside the rectangular duct, but it's like a filter, like at your house, whatever. The turning vanes can be removed and replaced. And so we offer
flaking. Was there flaking on the turning vanes?
On a few of them, there was. And so we offered to remove and replace those.
Okay, those are all of my questions. And I'm sorry if I interrupted Judge Rogers.
Oh. Okay. Thank you, counsel.
Thank you.
All right. Counsel for petitioner? I'm sorry, counsel for respondent, sorry.
Good morning, may it please the court. This appeal arises from a contract dispute between Archer and the FAA relating to the construction of the McCarran International Airport in Las Vegas, Nevada. Archer seeks review of 3 of the FAA's Office of Dispute Resolution for Acquisition rulings that were issued in the course of ODRA's adjudicating many claims that Archer asserted against the FAA. And the court
you
reviewed
heard the argument this morning as to the first issue. What's the basis for the agency's disagreement?
Your Honor, on the first issue on the timeliness or when the delay claim accrued, petitioners have asserted a theory of accrual that assumes that they have a direct cost claim, and they don't. What they have is a delay claim. And I think the Court of Federal Claims instructive in that it reminds us that we need to focus on the events that triggered the delay that are causing the injury that Archer is complaining about here. And the events that caused the injury, the delay, was when Archer realized in October of 2012 that there was a specification, there was an issue with the specification. And then following Archer raising that issue with the FAA issued a proposed contract change, 16. And we know from Archer's own statements that it is the combination of those 2 events that caused its injury, which therefore gives rise to the accrual of its claim. And we know that because on January 4th, 2013, Archer wrote a letter, this is at A582 of the record, telling its subcontractors to stop work pending, quote, clear design and direction from the FAA. And then February 7, 2013.
So what is
Archer,
your strongest case for the proposition that the definition of accrual under the regulation that applies in direct cost claims does not apply in delay claims?
Your Honor, that would either be the ASBCA decision in Robinson, which explained that once you know that there is a delay, the length of delay is then just the quantification damages.
You had no obligation to do anything, all right, until the agency told you to do something. Now, here, the contractor finds a problem, notifies the agency, and meanwhile tells his employees and subcontractors to stop work. And we're waiting to see whether the agency is going to say this work must be done according to item 10. Why isn't this case different from what you're describing?
Because the injury that Archer suffers is a delay. And
it doesn't suffer any injury until it's instructed to do the work. Is that not its argument?
That is Archer's argument.
On the direct cost claims?
Archer doesn't have direct cost claims any longer.
I understand that, but it's applying the standard there, interpreting the regulation and what it requires. And I'm trying to find out where you find authority that interpretation of the regulation does not apply in a delay claim where there has been no instruction to the contractor to do the work in accordance with this contract change proposal.
Your Honor, if we, for example, look at Archer's time impact analysis number 6, That's at A611 and 617. Archer directly ties its delay damages to the suspension of its activities due to the issues identified in RFI 804. And then explains further, this is at A617, that due to the time required for the FAA to correct the defective specification and layout, Archer is continuing to suffer delay damages. So the delay damages are fundamentally different kind of, it's a different kind of claim and a different kind of damage
Right?
than a direct cost claim.
So until the contractor is told to do something, the fact that it must stop work under the terms of the previous existing contract terms is not a recoverable cost?
Your Honor, it may be a recoverable cost,
Yeah.
actually. I mean, Archer's arguing that it wouldn't have any recoverable costs until the notice to proceed is issued, but Archer's actually seeking delay damages going back to its RFI 804, its request for information 804 in October of 2012. And
So help me understand what the law is in this situation. I'm the contractor, I have a contract, and I discover that one term of the contract isn't going to work. So I notify the agency, and the agency says, let us look at this. And so it looks at it and it comes up with a proposal. Meanwhile, the contractors had to stop work. I mean, there's no disagreement here that the stopping of the work was appropriate under the circumstances. Is there?
That's right, Your Honor. No, there's no dispute that they
Right.
was.
So does a contractor just have to absorb all the delay costs that it suffers when the agency says, go ahead? And now instead of being able to complete the contract within, let's say hypothetically, 12 months, it's going to take it 16 months. There's no way for the contractor to recover that? I'm just asking, I don't know.
Yes, Your Honor, there is a way for the contractor to recover that. The damage, the event that is causing the damage to the contractor is the uncertainty as to what work to perform. And so while waiting for an agency to give direction, a contractor may have a delay claim. Sometimes the delay will not occur until the agency gives a notice to proceed on a different path, but that's not the facts that we have here. And I don't think it's uncommon for a contractor to say to the government, we've found a problem, we need direction, and we can't perform until you tell us what to do. The alternative is the contractor proceeds along the line, along the path of the contract, even though it's identified in error, and then has to later on undo all of that work, which could create a claim for damages as well. So when the contractor identifies that there is a government-caused delay, which would, if the specifications are defective, that could be a government-caused delay. Once the contractor identifies that there's a need to stop working, that's when the claim would accrue. It accrues when they stopped working because of the uncertainty.
And you think they should go to AUDRA at that moment? ODRA at that moment?
Your Honor, the ODRA regulations do allow and actually
I understand that.
Well, they were required to.
They were required to go within 2 years, yes.
They were required to go to ODRA. Listen to what my colleague asked you. Well, they were required to go to ODRA at that point.
They were required to go to ODRA within 2 years of identifying the delay.
Why go to ODRA rather than seek an equitable adjustment? First of all, the contract terms contemplate a request for an equitable adjustment, and it's less adversarial, probably less expensive, probably more efficient to first seek an equitable adjustment. I've got the contract language here. It's at JA 136 to 37. If changes increase the time, I'm adding some ellipses here, but I don't think they're material. If changes increase the time required for performing the work, the contracting officer shall make an equitable adjustment. And that's at contract 3-10-1-16C. And then if you go to E, it says failure to agree to any adjustment shall be a dispute under the disputes clause. So it seems to me that it's contemplating a pretty efficient, relatively informal process where a delay happens that's the government's fault, and the contractor first, before it runs to the arbitrator, the government seeks an equitable adjustment. And then if the government fails to provide the equitable adjustment, then that's a dispute. Failure to agree to it shall be a dispute. And the statute of limitations is 2 years from once the dispute accrues. Why does your theory, I guess, why not do that? Why shouldn't Archer do that? Let's say this happens 50 times over the course of a multi-year contract. Your theory would have them go to ODRA 50 times when, in fact, they might get an equitable adjustment 49 out of the 50 times. Is that right?
Your Honor, the regulations and the contract require the contractor, when it files a notice of contract dispute with ODRA, to also serve it on the contracting officer, on the agency, and to attempt an informal resolution. ODRA recognized that in her in the opinion on statute of limitations at A17 note 9. ODRA recognized that ODRA gets into the adjudicative process only when the parties can't work it out through an informal process. And so it does, the regulations do contemplate a double track. And my understanding is that is because the FAA wants a more flexible and informal process than you might have, for example, under the Contract Disputes Act. And so there is a contemplation that there would be a notice of contract dispute filed to preserve your rights, but that ODRA would not, jump in and start the adjudicative process immediately, that there would be time for the parties to try and work it out.
Is that somewhere in the record? I mean, that does make more sense than what I thought your argument was. Is there somewhere in the record that if a contractor goes to the ODRA before the equitable adjustment has been decided, that it's normal practice for ODRA to just stay that proceeding until the equitable adjustment has either been granted or denied?
Your Honor, that would be in the ODRA regulations dealing with the adjudicative process, and I'm looking for that citation, Your Honor. Let's see, it would be 14 CFR section 17.29, where the ODRA process for contract disputes includes an informal resolution period of 20 days for the parties to attempt to informally resolve the dispute. During the informal resolution period, if the parties request it, ODRA can appoint basically a mediator. And so it is a very flexible process. Once you file at ODRA, you've preserved your rights, but there is an opportunity to work out the dispute informally without ODRA getting into the adjudication and discovery and things like that.
Can the clock for bringing a claim that the government failed to make an equitable adjustment begin running before the government fails to make the equitable adjustment?
Yes, Your Honor, and I think that was the point of the Federal Circuit's analysis in Electric Boat, and I recognize it's not binding, but it is well-reasoned.
So in this scenario, Archer would go to the ODRA and say, I am challenging the government's failure to make an equitable adjustment. And they could do that even before the government has decided whether to make an equitable adjustment.
Your Honor, the claim would really be that Archer is entitled to delay damages. And that's why you look at the accrual of the delay claim. And because there's no requirement to exhaust any kind of administrative remedy, as was the case in Electric Boat, they can go to ODRA and file that claim without seeking an REA, a request for equitable adjustment.
Thank you.
If there's no further,
Yeah.
I was going to move on to the cumulative impact claim.
Thank you.
Okay. Your Honor, the cumulative impact claim is quite a distinct claim. It is not a delay claim. It is not a direct damages or direct cost claim. And what Archer filed in its notice of contract disputes was claims that had specific headings that were addressed to specific, discrete, and independent events. And what's lacking from Archer's notices of contract dispute was any reference to a concern about overall cumulative claims pervading the entire project. And so ODRA committed no error when it held that that ODRA had no record of Archer filing a cumulative impact claim on behalf of its subcontractors. What Archer points to are, discrete paragraphs in its notices of contract dispute that relate to specific events, the ductwork or glass panels, PCC 16, but nowhere does Archer suggest, either in the labels of its claims or just in its allegations, that it has a claim based on all of those events taken together, plus some additional ones that give rise to a cumulative impact claim. And so the court should affirm ODRA's finding that Archer did not timely file its cumulative impact claim. The last issue that Archer raises is with the ODRA's conclusion that the FAA reasonably rejected the rectangular ducts. This is an issue that raises a question of whether there's substantial evidence supporting ODRA's decision, and that is, as the court is aware, means more than a scintilla of evidence, but less than a preponderance of evidence. And I think was undisputed before ODRA that in order for the rectangular duct to be conforming, the antimicrobial coating had to form the interior surface of the duct. That's the specification requirement, form the interior surface of the duct. That's at A125 through 126 of the record. And what that means, in Archer's own words in its reply brief, is that the adhesion requirements on this project, I'm quoting, was for the coating to form the interior surface of the duct and not delaminate. So forming the interior surface of the duct means that it has to adhere and not delaminate. And at that point, or at this point, we are now into a factual question about whether the coating for the rectangular duct was adhering.
And I
And
just
what-
clear,
Yes,
you're saying that as you read the record, there was no dispute about that before the agency.
I don't believe so, Your Honor. And
Okay.
in Archer's,
Everyone agreed.
right, Archer's reply brief says that the adhesion requirements on this project was for the coating to form the interior surface of the duct and not delaminate. And it was the delamination of the round ducts that triggered a concern about whether the coating was adhering to both the round duct and the rectangular duct. But, Your Honor, it doesn't have to delaminate in order for it to be non-conforming. There could be other indications that it is not forming, that's the language in the specification, that it will not form the interior surface of the
Just tell us
duct.
in your view, what was the substantial evidence supporting the finding with respect to the rectangular ducts? That there is a significant enough likelihood of delamination that you should prevail. What's your evidence?
The evidence would be the almost unanimous reliance on the ASTM D3359 testing, which indicated that there was a wild variation in the level of adherence. There were 68 examples of a 0B rating on the rectangular duct. And that, coupled with the delamination in the turning vanes, coupled with the fact that the experts were testifying that there was oil present in both the round and the rectangular ducts, albeit less on the rectangular ducts. And then you had...
All right, so counsel's going to come back and say the standard, that all of that I understand what you just said. They're going to come back and say, but the standard was more than was required.
Your Honor,
the ASTM standard, what's your answer to that?
My answer to that is that is fundamentally a factual dispute about what test should be used to assess whether the coating is adhering to the rectangular duct.
No, not adhering. The will likely not adhere is really what your argument on rectangular is.
That's
not
correct, Your
likely
Honor.
to, right, because you didn't have any visual evidence with respect to the rectangular, so you're talking about the likelihood of failure, right? I just want to make sure I understand. Okay. And so tell me now what your answer would be to their argument that will be coming, which is that the standard is more than is required under the contract.
That is, my response to that, Your Honor, is that the ODRA fact finder had listened to the expert testimony of Archer's expert, Mr. Rudd, found that listened to him, heard him say that he thought it was too rigorous of a test. And she, as the fact finder, ODRA as the fact finder, rejected that testimony in favor of evidence relating to the ASTM D3359 test and the testimony that there was oil present on both the rectangle.
Why is the test being rejected? I mean, the evidence with respect to the test.
The ODRA rejected the test that Mr. Rudd, the petitioner's expert, because he had essentially used a watered down test. He took a standardized test and then modified it to the point that it really no longer had.
Okay, no, that's not the gap. The gap, I'm just trying to make sure I understand this in my mind. The issue is they didn't reject the plaintiff's test. I understand that. But they accepted the standard test, which they claim now was more than is required. And what was the fact finding with respect to that? The more than required. Was there some answer given to that? In other words, the test that you're looking to, they're saying is more than was required.
ODRA found that it was reasonable for the parties to rely on that test because everyone had been looking at it before, had been using the test before the litigation. So when Archer hired SME to investigate the delamination, SME, Soils and Management Engineering, turned around and used the ASTM test. when GK hired SME to look at it, they used, SME used ASTM test. BioShield, the coating manufacturer, also used that test. So ODRA found that it was reasonable for FAA to rely in part on that test because that's what everyone else was using.
Okay, I hear your answer. Thank you.
The turning vanes are part of the rectangular ducts. Is that correct?
My understanding is that they are part of the rectangular duct. They may be sort of I want to say unique part of the rectangular duct, but they are part of the rectangular duct.
Why does, I mean, this is a friendly question. Why does the delamination, the turning vanes, not equate to a failure by Archer to strictly comply with the contract? Or does it?
The delamination, Your Honor, in the turning vanes was an indication that that there could be delamination in the rectangular vanes, but it was not. They are of a slightly different nature, and so, to be candid, I don't think that the delamination in the turning vanes alone would be a basis for rejecting all of the rectangular duct.
Yeah, that's helpful. I appreciate the candor.
If there are no further questions, then we respectfully request that the court affirm the decisions of ODRA.
So let me be clear so I understand what the test that ODRA was relying on showed as to the rectangular vents.
Your Honor, what it showed was that in various places in the rectangular duct, there was an adhesion rating of as low as 0, and then sometimes an adhesion rating as high as 5. And there were 68 instances where there was an 0.5 rating. I'm sorry, a 0 rating.
And where did the evidence come from that adhesion in the rectangular vents was improving?
That was the comparing test results from, I believe, Your Honor, it was like a June test result to some earlier test results using the ASTM 3359 test.
That's the test ODRA relied on.
Right. It was improving in some areas, and then in other areas, it was not improving.
So with that evidence, what was the basis for requiring replacement of all the rectangular vents?
The basis for it was the concern that there would be that some of the rectangular duct was likely to delaminate during the.
What I'm getting at is there were these problems, 68 problems, let's say, in discrete places. And there was evidence that adhesion was improving over time. Nevertheless, ODRA had substantial evidence for ordering removal of all, replacement of all rectangular vents.
Right. What ODRA.
That's what I'm having trouble understanding. In other words, you put this coating on, it doesn't adhere great everywhere at the beginning. But then over time, the testing shows its adherence levels are improving.
Your Honor, the adherence levels were improving in some places that, but not across all of the rectangular duct. And what Odra said at A97 of the record was that the record showed that the test results on the rectangular ducts were similar to that of the round ducts in various places. And so in the round duct was,
suppose the ducts are, I don't know, what, 500,000 feet long, and the 68 places amount to 1,000 feet. I didn't find, and maybe I missed it, any suggestion that the 1,000 feet problem dispersed over this hugely long vent meant everything had to be replaced. That's what I'm trying to understand. Where's the substantial evidence for that when the evidence was adhesion was improving?
Your Honor, it would be impossible for the agency to identify just the areas where there is, so let me back up, Your Honor. What they're doing is sort of spot testing the ducts. They could not, test the entire duct for adhesion levels across the entire duct. And so they're spot testing, and they can't, if they're
getting, it would just be too costly to do so.
My understanding of the test, Your Honor, is that it is essentially destructive. So you would,
I see.
You would have to, I think you'd have to take the ducts out to test them, and that would be counterproductive. And so what Odra is looking at is, okay, here's this evidence of adhesion levels being, varying throughout the ducts.
Improving. That's what I'm
improving in some areas.
Uh-huh. Do we know that these are not the 68 areas?
I don't know the answer to that, Your Honor.
Yeah, I didn't see any equation on that. Okay, thank you. Anything further on substantial evidence?
No, Your Honor.
Thank you.
So for these reasons, we ask that the court affirm the board's, Odra's decision.
All right. Are we ready for the replies? Mr. Straw?
Yes, there we go. Just had to unmute. Thank you. Yes, Your Honor, ready for the reply. Thank you. Just a few points first on the proposed change item 16 or change 16 item 10. Counsel for the FAA just referenced the Robinson case, and that case is distinguishable because there the contractor thought it had to wait till the very end of the project, till all the work was done before it could even file a claim. That's not what Archer Western here is arguing, but importantly in Robinson, the claim held, or the contractor, excuse me, the court held that the claim accrued when the contractor actually began performance of the changed work. Here at the earliest, that was when there was an order to do that work. And at the latest, it was when the administrative process, the REA process described in the contract had been exhausted. In fact, counsel for the FAA just stated with respect to the electric boat case that in that case, there was no requirement to exhaust an administrative remedy. So that case is distinguishable here. With respect to disruptions, then, two quick points on that. The Norman case, which was decided by the NASA Board of Contract Appeals, found that where there was a waiver of direct costs, cumulative impact claims were not waived. They could arise from the same operative facts and reference the Placeway Court, where the Federal Circuit reversed the Court of Federal Claims when the Court of Federal Claims put too much emphasis on form over what facts were actually pled. Here, the notice of—
But where is the additional allegation that was needed here?
With respect to disruptions, Your Honor?
With respect to the overall disruptions. In other words, there was a disruption as to this matter, as to that matter, as to this matter, as to that matter. And moreover, as to the entire project, there were these disruptions.
Understood. Thank you.
And
So
where
here,
is that latter part in your client's petition to?
So here, the references to cumulative impacts are in the 4,000 plus pages of supplemental information that ultimately became part of the dispute file, which is similar to the Resnick case, which was an ODRA decision that found that they would not be, quote, overly technical, unquote, about what constitutes a notice
And
of contract.
so what do we find in the supplemental record that says, in addition to all these individual problems, there was this overarching problem?
There are references throughout that documentation, Your Honor, portions of which are in the appendix. The whole thing is not in there, but portions are that reference cumulative impacts, trade stacking, ripple effects, and these are all synonymous terms related to and reflecting cumulative impact claims.
All right, so ripple effect, and what's the other?
Trade stacking, inefficiencies are others, lost productivity is another synonymous term.
And the agency never considered this? Is that your argument?
That's correct, Your Honor. And for that reason, we would ask that the court find that the disruption claim was arbitrarily dismissed as untimely, and that the proposed change 16, item 10, was similarly arbitrarily dismissed.
So in your opening brief, do you cite to this supplemental record specifically to ripple effect, trade stacking, lost profits?
Yes, Your Honor. There are references in there to the supplemental information that became part of the dispute file.
I understand that, but specifically as to these items that you just identified.
As to these terms, ripple effect and lost productivity, I believe so, Your Honor. I'm sorry I don't have the pages.
Well, I'm sorry too, because I didn't find them. Doesn't mean they're not there. I didn't find them. That's what I was looking for, something more than these discrete claims, this additional argument. And in your brief, you're saying you didn't cite them, other than refer to the supplemental materials.
I'm saying we did, Your Honor, and part of those supplemental materials are part of the record.
You understand what I'm getting at is if you tell the agency we have a cumulative impact claim and all you have to do is look at these supplemental materials. And here are 1,000 pages. Where? What specifically? That's what I'm trying to understand. And the argument is that wasn't done here.
That the lines were not connected from the notices to the supplemental information. Is that correct?
No, that the supplemental information, in fact, cured the defect as
we believe
to failure to specifically allege a cumulative impact claim.
We believe it did, Your Honor, to the extent there was a defect to begin with, and the FAA was not prejudiced because they filed responses.
No, counsel, what I'm saying is I didn't see it in your brief, and I am happy to acknowledge maybe I overlooked it, but that's what I was looking for, something that said if you look in the supplemental filing, you will see at a whatever that we had this ripple effect, we had lost profits, etc.
Those references were made to the FAA, Your Honor, and the FAA responded thereto for over 3.5 years with expert testimony. So my point is, Your Honor, if they had never been, if the lines had never been connected, if the references to the supplemental information
all
had never
I'm
been
getting
given,
at is you're in the Court of Appeals, and in your opening brief, don't you have to identify with some specificity the nature of your claim? Then the agency comes forth and says, well, you made all these discrete claim arguments, but you never alleged the cumulative overall impact aspect of your claim. So I would have expected on reply that you would have said, no, if you see the supplemental record at whatever it is, JA or A, you'll see. And I didn't see that there either. In other words, whose burden is it to identify the record to support your claim.
At
And you're
the
going to notice that the agency is saying all you did was make these discrete claims.
At the outset, I agree, Your Honor, it's Archer Western's burden to provide notice to the FAA of those claims. But then in deciding whether those claims were timely alleged or adequately alleged, I think the case law establishes that the ODRA has to look at not only the notice of contract dispute, but the information that was provided to support it with further detail, like the Resnick case.
All right, thank you, counsel.
Thank you.
Okay, Your Honor, in regards to a couple of things, in regards to expert testimony, we do believe that it's expert testimony is necessary to establish whether there's going to be future delamination. And we do not have that in this case. There was no expert, there was no one from ODRA that was qualified to make a determination as to whether there would be future delamination of the rectangular ductwork. Yes.
On review that's just inquiring into whether there was substantial evidence, why is it not enough for the government to say everyone agrees the round ducts didn't meet standards? They didn't meet standards because they weren't cleaned in an appropriate way before the special stuff was put on them. And the same people who didn't clean them well were the people who were responsible for cleaning the rectangular ducts well.
I can address that, Your Honor, because even the government or even the FAA acknowledged early on in the process that there was a different methodology that was being used to manufacture the rectangular duct versus the round duct. When you manufacture the round duct, there's an oil material that is lined that helps in the circulation in preparing the round duct. You don't have that with the rectangular duct. The rectangular duct is just bent with a breaker. And in fact,
let's say I hire someone to clean my house, and they use a certain method for cleaning the floors, and they use a certain method for cleaning the carpets, and they do a terrible job with the floors. Isn't there at least a scintilla of evidence they probably did a crummy job on the whole house?
We don't know whether they were the same laborers or whatever. I mean, that's like saying, somebody is convicted of a crime. Well, given the fact that it was in the same environment, his brother was raised in the same environment, the same people, the same education. Well, he's also has a problem there. I mean, there's just no link to the manufacturing process and that the same people were doing it. The other thing I'd like to raise is the 68 O tests that the government raised. The 68 O tests were not taken while the ductwork was in place. The ducts were tested after the duct had been demolished. It had been ripped out of the building. It had been taken into a garage where it was twisted, mangled, whatever. And the tests were made there. We do not believe that that is an accurate way to take the tests. And that was done after the ductwork was removed. All of the tests that were done prior to the ductwork being removed showed a significantly higher adhesion test using the ASTM 359. In addition, the government's own expert witness testified that the ASTM D359 was too rigorous for this application. And the government talked about the modified test. So the modified test wasn't in relationship to the D359. It was 3359. It was in relationship to an air velocity test, which there is a ASTM abrasion test where you shoot air against the surface to see if it'll delaminate. Because this is a filtered system, there is no sand or anything else. The expert just used velocity air. And what he found was even on the 0B tests that the government had rejected, that the velocities withstood pressures of 5 to 13 times higher than what would be experienced in the conditions that the ductwork were operating in. In addition, on those tests, the government raises, well, this was what was used by everyone. Well, keep in mind that the very first test that was done, where they tested the rectangular duct, there were 28 locations where they tested, and 2 of them showed 0. Well, the government, as well as Gallagher, Kaiser, and Archer Western, said this is a general test to give an idea of adhesion. It's not a spot test. You don't look at the outliers. And so what happened is, even though the rectangular duct had 0B rating at 2 of those locations, the government said that's fine. It doesn't look like the rectangular duct has to be removed. It's acceptable. And during the course of the project, when the government was addressing the ASTM test, they were also saying, Gallagher, Kaiser, and Archer Western, well, what is satisfactory? What is a passing test? Is it going to be a 2B, a 3B, a 1B, whatever? And the government gave absolutely no indication. The government did a wholesale rejection of the rectangular duct based upon conjecture and speculation, without expert testimony, without expert opinion as to whether this would delaminate in the future.
All right. Anything further?
Nothing further, Your Honor.
Thank you. We'll take the case under advisement.
Thank you for your time today.
Case number 21-1719, Saint-Gobain Performance Plastics Europe versus Bolivarian Republic of Venezuela, appellants. Mr. Yalowitz for the appellants, Mr. Yellen, amicus curiae, Mr. Llanos for the appellee.
Good morning, counsel for appellant.
Thank you, Your Honor. May it please the court, Kent Yalowitz of Arnold and Porter for the Republic of Venezuela. The district court in this case misconstrued the Hague Service Convention. Its judgment should be reversed, and the case should be remanded to give the plaintiff an opportunity to effect service correctly. The practical question presented by this case is what to do under the Hague Convention when main channel service on a foreign sovereign fails or is unavailable. We simply ask the court to apply the convention as written and give the plaintiff the opportunity to effect official, formal service through diplomatic channels. If the court grants this relief, the plaintiff will not lose its legal claim. We have been telling the plaintiff this since August of 2019. The plaintiff has refused to follow that process, and the Republic is now faced with a troubling precedent. We ask the court to correct the district court's misstep and apply the convention as written. As the court
I'm sympathetic to your argument that 15(1)(b) may not even apply in situations where like this, where Venezuela has made an appearance. But I'm not sure if you argued that below. If you did, can you point me to where in the record you did?
I would have to look for that and send the court a letter. I'm fairly confident that we did argue that to Judge Contreras and to Judge Stark, but I'd have to look for that and send the court a letter.
Well, and even if you didn't, your opposing counsel has not necessarily argued that you haven't. So it may be that they have forfeited their forfeiture argument.
I was about to say that was not an issue raised by the appellee. So if there was a forfeiture, it would have been forfeited in this court.
do you read 15.2 to also only apply to situations where the defendant has not appeared?
Yes. Yes, 15.2 is a safety valve for 15.1. Like 15.2, it only applies where the defendant has not appeared, and it only applies it only applies to allow entry of a default judgment in specified cases. It's not a freestanding service authorization, and so it doesn't satisfy. Nothing in Article 15 satisfies the requirement of service of process in the FSIA. And as the court knows, personal jurisdiction under the FSIA requires service. And so any inconsistency between 15.2 on the one hand and the FSIA on the other would be resolved by the FSIA's superseding later in time provisions. The district court acknowledged that that there is no explicit authorization of service in the text of Article 15, and there are other articles that expressly authorize service. Article 8, 9, 10, 11, and 19. Article 15, it just isn't one of them. And then, to the extent that Article 15 references service at all, it points us elsewhere in the convention. 15.1a refers to a method prescribed by the internal law of the receiving state, and 15.1b refers to another method provided for by this convention. And when 15b says another method provided for by this convention, it's referring to another method to effect service. There's also a structural argument with the appellee's position as well. One treaty should not be read to strip other provisions of meaning, but Saint-Gobain's argument that delivery to the central authority of Venezuela would be enough to effect service would render Article 13 superfluous. Article 13 permits a foreign sovereign to refuse to complete service if it deems compliance to infringe the receiving state's sovereignty. Drafting history, which is available in cases of ambiguity, also confirms that subparagraph B, which is what the district court relied on, establishes a heightened standard where service was not achieved by the internal laws of the receiving state. We've set forth that negotiating history with our translations in our reply brief, and I would reference the court to volume 3 of the negotiations, particularly page 95. I would also defer to the United States on the construction given by the parties, particularly the United States executive, which the courts hold carry great weight. The views of the executive carry great weight. I would say that the views of the Justice Department in this case, which are long established, they're not tailor-made for this case, they're long established and pre-existing, are reasonable and indeed consistent with the way that district courts in this circuit have treated service on the United States in domestic cases. Finally, I want to turn to 3 aspects of the district court's rationale that I think are unpersuasive. The first and most important is that treaties, because they are made by the president and ratified by the Senate, are a function of foreign policy. And so it is particularly improper as a matter of the judicial function to find gaps in treaties and attempt to fill them by inferring authority that's not explicitly provided in the text of the treaty or convention. Second point I'd like to make about the district court's decision is that the district court relied on unpublished out-of-circuit cases that either had little or no textual analysis or indeed were not even about Article 15.1. The only appellate decision relied on by the district court was a non-precedential decision that turned on 15.2, not 15.1. And at bottom, the district court was relying on what it perceived as a moral hazard, or what it called the risk of evasion of service. The convention and the Foreign Sovereign Immunities Act have a built-in safety net against moral hazard, which is service through diplomatic channels. That form of service has been used to serve process on the Republic repeatedly over the last 3 years without incident or complaint from any litigant that we know of. Service through diplomatic channels, at least at the time the convention was drafted in the 1960s, was actually the preferred method of service on a foreign sovereign, according to the House report that accompanied the Foreign Sovereign Immunities Act. In fact, as I mentioned, we explained this to the appellee in August 2019 in our very first brief. And in February of 2020, I actually stood, I'm sorry, go ahead.
Let me ask, at one point in the appellee's brief, there's a footnote along the lines of, you know, this whole case could just go, they would just agree with you if you'd be willing to post a bond. Do you have any thoughts on that?
Yeah, the Republic is not in a position to post a bond. That's just not feasible. That's not, and the convention doesn't
The amount of
require it.
money involved in the claim?
The claim is I think a $30 or $40 million claim.
42 million. So it's just a bond saying they're bankrupt.
As the court is aware, the Republic of Venezuela at this time is facing an economic, humanitarian, and political crisis of unprecedented proportions. And in particular, the Guaido administration, from whom we take instruction, is operating on a shoestring budget. We have no ability to make special deals with litigants who don't follow the rules.
Fair.
Unless the court has questions, I think you have my argument.
Thank you. Your counsel for appellee. We have amicus. Pardon me. We have counsel for amicus, the United States, Mr. Yellen.
Thank you, Judge Rogers. May it please the court, Louis Yellen from the Department of Justice on behalf of the United States. Your Honors, the district court made two fundamental errors in this case. The first error was in construing Article 15 as a service provision, whereas it's a default judgment provision. The second was in concluding that even the requirements for default judgment were satisfied in this case. The first error, Your Honors, is not a close question. It's as if the district court here misconstrued Federal Rule of Civil Procedure 55 governing default judgments as a service provision similar to Federal Rule of Civil Procedure 4. By its plain text, all of Article 15, what the United States has referred to as 15.1 and 15.2, refers explicitly to circumstances, requirements under which a court may enter default judgment against a party. The only references to service are references elsewhere to service as required under the convention. And service simply was not made in this case pursuant to a provision of the convention. The thing that I'd like to emphasize with respect to that is under 15 sub 1, which is the only provision of Article 15 that plaintiffs have relied upon in this litigation. A plaintiff, default judgment may not be entered unless, and I'm quoting now from Article 15.1b, quote, the document was actually delivered to the defendant or to his residence by another method provided for by this convention. Plaintiffs completely ignored the latter part of that qualification, that is, by another method provided for by this convention. And they act as if 15(1)(b) authorizes entry of default judgment simply by actual delivery. Now, I want to hasten to add, this is error on top of error, because the threshold question is whether or not Article 15 has anything to do with service, provides any requirements for adequate service, and it simply does not. The last point I'd like to make, Your Honors, is, as Mr. Yalowitz pointed out, the FSIA service provision, which after all is the governing law in this case for determining service, does have a fallback provision if service is not able to be affected by any of the preceding provisions. That is, A4 provides for service through diplomatic channels. And one thing that's quite important, I think, for some of the moral hazard arguments that plaintiff has made here is that A4 service through diplomatic channels, is effective upon the transmission by the State Department of the papers through diplomatic channels. That's in 1608.
You suggested in your brief that really a simple solution, you say here, the case should simply be remanded to the district court to allow the plaintiff to attempt service through diplomatic channels. How would that work? Assuming we agreed with that, we would remand and our judgment would say what to the district court? The district court, you're wrong in suggesting that service can be effected through the central authority. That's not what the law is. But there can be effective service by attempting through diplomatic channels. And what happens?
Well, at that point, Your Honor, as our brief noted, multiple suits against Venezuela. This
No. I understand the possibility is real. I'm being very mundane.
Yes.
I'm a district court judge, and I have a judgment that says allow them to effect service through diplomatic channels. And let's assume this is the district court judge's first day on the bench, and he or she says, "What does that mean? What am I supposed to do?"
I understand, Your Honor. The statute is helpfully very specific on this point. 1608A4 requires a plaintiff seeking to serve through diplomatic channels to ask the clerk of court to transmit the papers to the State Department. And the statute specifically identifies the office in the State Department, that is the Director of Special Consular Service. And then the secretary shall transmit one copy of the papers through diplomatic channels to the foreign state.
Is the case still pending before the district court judge?
It is pending in the sense that any case before service has been effected is pending before the district court judge.
So the district court judge says, I'm reserving judgment. I'm trying to figure out, I want to be very. District court judge says, what? Okay, the Court of Appeals has sent it back to me saying, my assumptions about the law are simply wrong, but we can use this alternative process. And so now I am ordering what? Until when?
Until when?
Ordering what? And then until when? I really want, play judge. What?
I understand, Your Honor.
What do you do?
Order.
What are you saying to the parties? Here's
You're
what
saying to the party. So if I might be quite explicit, Your Honor, it is the plaintiff or the party that's seeking service. It's their discretion whether they want to effect service or not.
I understand they can say forget it. Let's assume they want to continue to try and pursue it. Go ahead.
Understood, Your Honor. In all other cases that we've cited in our brief, if this court looks at the docket, what the court will see is that the party seeking to effect service provides an update to the district court about its attempts to effect service. And ultimately, those parties have told the district court, we've not been able to effect service through these other methods. We are now attempting to effect service through diplomatic channels. We are going to ask the clerk of this court to send our papers to the State Department for it to serve through diplomatic channels. The district court
order says,
yeah, I'm trying.
If Saint-Gobain wishes to proceed
right
with efforts to obtain service, it should advise the court within 5 days and update any papers that it wants to submit for the clerk of the court to transmit those papers to the ex-office in the Department of State.
All
So,
right.
Your Honors, the amount of time, if this is really what you're asking about, like how much time should the district court give Saint-Gobain, that's a matter within the district court's discretion.
No,
It's not-
You're amicus.
I'm being at a very low level. Maybe my colleague Judge Walker, he was a district court judge, he can tell me. I'm just.
Not for very long.
Yeah, district court judge is sitting there and assume the district court judge knows nothing. And I say that
So I can-
respectfully. All I'm asking you is, what do you envision happening? It's like talk to someone in the world who knows nothing about the law. So the kid says to you, well, what happens, counsel? What do they do? The Court of Appeals does what? And the district court does what?
So I will tell this court, what district courts have typically done in this
No,
case. They have given.
Tell us what the order says.
Right. What's the district court going to order?
With respect, Your Honors, I will give you an example of an order that could be entered.
Thank you.
However, it is not, with that, I must make the following caveat, Your Honor. It is not the appropriate role of the United States to direct the calendaring of the district court.
And
You're amicus in this case.
I understand, Your Honor, but with
Just
the
help us out.
deepest
You're not
respect,
directing
Give
us.
us your best thought on how
You're making this too hard. We're just trying to get a picture, that's all.
order.
I completely understand, Your Honors. District
No,
courts
you
have
don't.
typically asked.
We're trying to help you to understand what, we want a very low level of information. We really
I
do.
understand, Your Honor. I do understand, Your Honor. The reason why I'm resisting, and I don't mean to be difficult with the court, is that what I can tell you is traditionally the courts in the other cases that we've cited have asked for updates every 30 days from the plaintiff about the plaintiff's efforts to make service through diplomatic channels. That would be
All
an
right,
appropriate.
so let me ask you this, along the lines of Judge Edwards' question. Suppose in 5 days, under my hypothetical, Saint-Gobain advises the court, thank you very much, but I'm not interested. Then what happens to the case? Does our order say anything about that?
The case would otherwise be dismissed, Your Honor, because there is no service upon Venezuela.
All right. Anything further?
The one thing I would like to underscore, Your Honor, just because I fear that I may have created some confusion with the last colloquy. The case, if the court remands it along the lines that the court was just suggesting, it would be in the exact same posture as a case in which a plaintiff or other party has not effected service on the defendant. And so whatever happens in that case would be just as if there were no service.
So in other words, are you suggesting our order should not go into all of this, but simply say we reverse, period? And then it's up to Saint-Gobain as counsel for the Republic has said.
I think that would be.
It can make its own decision about what it wants to do. Why does the district court have any more role to play?
Your Honor, that would be a perfectly appropriate order. It would be helpful in light of the dispute that's occurred between the parties for the court to give an interpretation of 1608A4 and explain that the avenue that was available was service through diplomatic channels. I think if the court were hesitant. I'm sorry, Your Honor, I did not hear that.
A little advisory opinion.
With respect, Your Honor, it wouldn't at all be advisory. That would be specifically explaining the avenue that was available.
Have any jurisdiction.
This court has jurisdiction over an appeal concerning a dispute between the parties.
If we reverse, the case is gone, right?
The case is in the same posture as if the plaintiffs
Yes
have
or
never
no,
adequately
counsel?
served. No,
Yes
Your
or
Honor.
no? All right. The answer is what?
The answer.
There is no case in the left in the district court to adjudicate.
Your Honor, with respect, this was an enforcement action seeking to enforce an arbitration award. The question would be whether or not the district court could pursue anything on the merits. It cannot until there's proper service.
So the answer is there's no role for the district court if we
Unless Saint-Gobain acts. Yes, Your Honor.
Period. Saint-Gobain is an independent agent. It can decide to do whatever it wants. And as best I can understand, and maybe counsel can advise me here, Saint-Gobain is concerned about something else. And I'm not clear what it is. In that footnote about the bond. And you have suggested that in some other cases, the district court has sort of held on to the case and asked the party to report every 30 days on how is it doing on diplomatic service. And
Your Honor, I beg your pardon, Your Honor.
And suppose Saint-Gobain comes back and says, we've tried, but it's futile.
That's not a hypothetical, that's realistic, Your Honor. The United States has effected service on Venezuela through diplomatic channels, typically within a number of weeks at the outside.
Mr. Yellen, that's in the past. We're dealing with the present situation. Saint-Gobain is concerned about something, all right? And it's gone through this very expensive litigation because it wants its award enforced. And it doesn't want to lose anything in the process. So I thought that might be what Judge Edwards was getting at, since Judge Edwards knows how to craft these orders. But this is sort of, a foreign area in some respects.
So respectfully, Your Honor, I'm making a representation about what the United States State Department will do in this case if Saint-Gobain asks it to make service through diplomatic channels.
Is there any possibility that the U.S. will not be able to effect service? I think that's part of the question Judge Rogers is asking. What happens if that happens? That is, the district court says, I'll wait a reasonable period of time. You have to report to me. And then it comes back from the U.S. We couldn't effect service. Is that a realistic possibility? I know it has happened routinely, but is it possible they could not? And if so, what is the U.S.'s view on what now is the possibility for plaintiffs?
It is not a realistic possibility, Your Honor. Venezuela has indicated its willingness to accept service through diplomatic channels. We have the diplomatic contacts. The State Department has represented.
Let me try to be really clear. We're really not trying to hold you up or make this more than it ought to be. Let's assume what has been the routine and most likely event doesn't happen. The people who have assured you we will accept service next week say, we changed our mind, it's not happening. What happens then in your view?
In our view then, Your Honor, the district court has no subject matter jurisdiction if it is determined that service cannot be made because a district court's jurisdiction.
There is no, under the law, it says at a certain point, the plaintiff has to at least show that reasonable attempts are made.
No, Your Honor, this is quite critical. And if I might be very clear.
Yeah, I want you to be.
28 USC 1330 provides for subject matter jurisdiction in the district courts in FSIA cases when service has been made pursuant to 1608. If service is not affected under 1608 for whatever reason, a district court lacks jurisdiction.
Even if they've made reasonable efforts.
Yes, Your Honor. As this court in Transero.
I just wanted to hear your position on that. Okay.
Yes, Your Honor. Even if they've made reasonable efforts, 1608 in suits against foreign sovereigns, the formalities are critical, as this court has recognized in Transero.
We get your argument. Thank you very much.
Thank you, Your Honors.
All right, counsel for respondent here? No, counsel for appellee.
Yes, thank you, Your Honor. May it please the court, my name is Alex Llanos, and as the court just noted, I'm here on behalf of Saint-Gobain Performance Plastics Europe, the appellee and the plaintiff in these proceedings. And just for a moment, because I think there was some confusion implicit in the discussion before, I want to return to a couple of facts. First of all, just, to remember that this is a case about an arbitration award rendered by a tribunal under the Washington Convention. As I'm sure the court knows, pursuant to that convention and also pursuant to 22 USC 1650A, arbitration awards already have the status of of judgments of one of the highest court of one of the several United States. So it's not like a commercial arbitration award. This is already a judgment under the law of the United States. And then to move forward with the enforcement, we initially filed a petition in Delaware to enforce the award, and we served. This is the other thing that I thought was said that was, mistaken. We did serve the petition on Venezuela. We did it by means, it's established in the Hague Convention. We sent.
No, that's not true, counsel. I mean, you just can't find support for that. The district court seemed to assume you could get to the central authority, and that's an effective service process. That is wrong.
No,
that is wrong. That is simply, and that is all you have done. You have got to show that you affected service on the Attorney General. When you read all of these papers and the law, and you didn't do that.
No, we have to.
And you didn't get a certification of service either.
Your Honor, we had to serve the papers on Venezuela, and we did serve the papers on Venezuela.
You did not serve. You did not
recall that.
Wait. I'm one of the three people you have to convince. You might want to know what's bothering me. Okay, you did not affect service of process on Venezuela. There's a way to do that, and it's not through the central authority. It has to go to the Attorney General. There's a way to do it. District Court, respectfully, was mistaken in its assumption about how you affect service of process, and seemed to be concerned that it might be unfair not to allow it. Well, that's too bad.
Well, no, Your Honor. There are two methods of service. The United States would, for whatever reason they want to, pretend that there's no opportunity under the Hague Convention to serve papers through the central authority. There are. In this case, the central authority designated by Venezuela is Venezuela. It's the foreign ministry.
Not to serve process. Counsel, really, we've all read this. It's not to serve process. It's to receive papers. They've then got to get it to the Attorney General and give you a certification.
No, it is to serve process. That's completely wrong, Your Honor.
Okay, well, then we are looking at very different documents. There's nothing to support that interpretation. And in that respect, the United States is exactly correct based on my read of what's before me. You cannot affect service the way you did it. And you have to have a certification that went to the Attorney General of Venezuela. It did not.
Well, we didn't. It's true we didn't get a certification, but that's because Venezuela itself pocketed the documents. All
you're doing is explaining to us an unfortunate situation.
It's not an unfortunate situation.
Well, from your standpoint, it's certainly unfortunate. You would have wished that this would have been enough, but it isn't enough.
Well, no. It is absolutely enough, because the entire premise of Article 15 is that where there is actual service, then nothing else is required. And here, the only thing that didn't happen is Venezuela wearing one hat, the foreign ministry, the central authority hat, the same entity, the foreign ministry, which is, of course, the entity that is designated to deal with the outside world, just put the documents in its pocket instead of acting. That's simply not what Article 15 is designed to do. The situation might be different if we were trying to serve, some random individual in Venezuela, and the central authority said, well, I tried to find that random individual, but I couldn't. Here, the random individual is the same person who is the central authority. So what the district court said, and multiple district courts have said this, by the way, and
that's why we have courts of appeals.
Well, absolutely, Your Honor.
Yeah, and you're mistaken, respectfully, on my read. And we still
I would urge you to
and I don't know why you don't take that as, unless my colleagues tell you, no, you're right on track. I don't know how you can get that read out of it. And so what else should we be thinking about if that read, the read that I'm giving you, is a problem? What do you got left? I think you have a huge problem. You have to affect service, and you can't do it through the central authority, and you have not served the Attorney General of Venezuela, which you must do.
Well, Your Honor, again, I have to disagree because the Hague Convention expressly permits service through the central authority. It's not like that option doesn't exist. The
Yes, let
only
me
thing,
say,
yes.
you keep saying service through
Yeah,
central authority. No one is disagreeing with that,
Right.
but that's not the same as effectuating legal service on Venezuela. And what I'm trying to understand here is, the Hague Convention, while it does a lot of great things, it also protects defendants. And one of the things it seems to me that your argument overlooks is it may well be that someone is in this position of Saint-Gobain and it sends its papers to the central authority and nothing happens. And the convention contemplates that situation. All right. Then Venezuela, Saint-Gobain has to figure out another way to serve Venezuela if it wants to proceed in the US courts.
well, I think the critical distinction here is between a situation where we're trying to serve someone, a third party in Venezuela, and when we're trying to serve Venezuela itself, where
All
the
right,
foreign
let me
ministry.
ask you a question.
Yes.
Then, the footnote in your brief
Yeah.
about a bond,
Yes.
can you explain to me what your client is concerned about absent a bond?
Well, obviously, Venezuela is trying to play cat and mouse here, and that's been the situation over and over again. Remember that they didn't, although they had actual notice, they didn't show up until the last day before default was issued, and then they raised this issue, and then they've obviously had actual notice for the better part of 2 years, even on their own account of the facts.
But actual notice is not good enough here.
Well, it is when it's
Under
the
the
product of
convention.
service.
No, what I'm getting at is the convention says, here's how you can serve a foreign sovereign. And you either do it my way or there's no service.
But
As a
we
foreign
did do service.
The
for
Foreign
things-
Service says, if you want to do it one way, then you can send your papers to the central authority and it will forward them, all right, to the Attorney General. So that didn't happen. So
Well, no, our position is it did happen. The only thing that didn't happen is they refused to send the paper to confirm it.
is there any proof that the Attorney General has received your papers? Have you received a certificate?
Well, no, we haven't received.
All right, so now what do? And I'm interested, in this footnote, because I know that both judges had footnotes about Venezuela. And I'm interested to know why your client won't pursue, if you care to say, diplomatic service.
Well, for one thing, Your Honor, it's just going to reset the clock. We've already waited a solid 3 years to get to this point. The idea that we can just, go around in circles on a situation where we provided the papers to the Venezuelan government, and by dint of their own refusal to perform the simple administrative act that is their obligation under the Hague Convention, they can thwart this process and just ask us to run around in circles for another 2 years. It's just, it's
what do you think
frankly
you
a
have
perpetration of fraud on the court.
What do you have to do to affect diplomatic service?
Diplomatic service is reliant on the United States then transmitting the papers to Venezuela, and then once again, Venezuela acknowledging service. As we've already seen, they have zero interest in doing that.
Well, so there's, what is it, a postage stamp to send your papers to the State Department?
Well, no, it's years wasted, Your Honor. It's not a postage stamp. It's years wasted in starting this proceeding all over again.
Well, I understand that, but if you lose here, what do?
well, if we lose here, we'll restart the clock because we have no choice. But the choice is before you right now as to whether you want to do that or not. And we're saying,
No,
well,
really, the choice is strict construction of the convention.
the strict construction of the convention is pursuant to Article 15, that they have received actual notice, and therefore it was perfectly appropriate for both district courts to infer that there was actual
It
notice.
doesn't say actual notice. It says actual notice in conformity with one of the rules of the convention. I'm paraphrasing.
Well, yes, and we did conform with the rules. On our part, we
What
submitted it
rule?
to the Venezuelan
What
government.
rule?
I'm sorry?
What rule?
What rule?
We're totally missing you. We're reading the same documents. I mean, that ought to give you a clue. I mean, we totally don't understand what you're talking about. There's nothing, when you read the relevant legal papers, there's nothing suggests that you can affect service of process through the central, by merely giving papers to central authority. There's nothing that says that. Nothing.
But that's the very purpose of Articles 3 and 5, Your Honor, is to serve. And mind you, we've served this process in this manner in a number of cases.
Well, yeah, because maybe the central authority did what you hoped it would do, which was to serve the Attorney General.
Well, not what we hoped it would do, but what it's obligated to do.
Okay, it's fine, but then what happens when they don't do that? That's the situation you're in. You have to have something to show that they did it. There is nothing to show that here.
Well, we have their certificate of receipt of the papers.
I don't know how else to raise my concerns. I just wanted you to understand.
What is the concern, Your Honor? I mean, I think it's
concern is the central authority is not how delivering papers to the central authority does not affect service of process. That's the concern.
Venezuela said, do it my way or there's no service.
No,
the fallback is diplomatic service.
Right.
But Venezuela doesn't have that authority.
Yes,
to
it
say,
does.
do it my way.
Yes, it does. That's the whole point. These states signed on and they could come up with schemes of their own.
No, they have to follow the Hague Convention. That's an obligation on their part.
Yes. Okay. So we have no idea of why your client is reluctant other than time to pursue diplomatic service.
That's an entirely justifiable reason, Your Honor. Plus,
I'm not suggesting it's not a reason, but I'm saying that is your reason.
I wouldn't say that there's any other. I mean, if
right.
Other than also just the fact that the Hague Convention is being thwarted, like the Venezuelan state has obligations. A treaty it has multiple parties, and there are implicit obligations on the parts. So when a state appoints a central authority or designates a central authority, they're saying that this central authority will do its job, right? So essentially, what Venezuela did here by not doing its job is a violation of the Hague Convention.
No, but what we're trying to get you to focus on, and I understand you don't want to, is that, these foreign sovereigns signed on, but they just didn't open themselves to service willy-nilly. And they gave they gave you a fallback.
It has to be consistent with the law of the national state. That's when you read the conventions, that's what it says. And consistent with the law of the national state, there's nothing to indicate that Venezuela has agreed that delivery to the central authority is effective service of process. I don't know how you missed that. I mean, it's just not there. It's not there. It says it has to go to the Attorney General. That's consistent with the law of the state of Venezuela.
Well, Your Honor.
And that's what the conventions say. When you read all of what's before us, the relevant law before us, you have to be consistent with the law. And you may run into problems. There's no question about it. And that's why you sometimes may have to use the U.S. to effect service for you through diplomatic means. But in any event, I think it's important. What we're trying to say is important for us that you understand our concerns, because the concerns leaped out for all of us in the same way.
Well, I have significant concerns with the idea that we want to allow states to designate authorities and then have them not do their job, even though this central authority is the very same person. The foreign ministry is the state. The attorney general is the state. They're not separate persons. There's one person. It's Venezuela. Venezuela is the respondent here. And all we're saying is that Venezuela, wearing one hat, put the documents in its pocket and pretended it never happened, and we're going to countenance that. And I have a serious problem with the judiciary countenancing that kind of conduct. And I would think that you would as well.
Even
And
if
for that
the
reason, I
convention
ask that you affirm.
signed on to a treaty that allows it.
It does not allow it. That's
I
precisely the
know,
point.
because you want to interpret the terms of the treaty. And that's what the district courts wanted to do too.
We can promise you we're going to follow the law. We don't do what we prefer to do. We follow the law. So we can give you that assurance.
All right, anything
Thank you.
further, counsel?
Not for me.
All right. Do you want to comment at all about the nature of our order to the district court, or?
Whatever order you make is at this point, I mean, whether you remand the case or you dismiss it, the award is already, as I said before, under 22 USC 1650A, a judgment of the highest court of one of the several United States. If you order that the case be remanded and then we refile, or we simply refile it, it doesn't change things. So I don't think that's a significant distinction.
Okay, thank you, counsel. All right. So counsel for appellant, anything further?
Thank you, Your Honor. I have three things further. Number one,
What are they?
okay. So first of all, I want to clarify or really correct my statement to Judge Walker. Judge Walker had asked about the no default situation, whether we had argued that to the district court. And while we were listening to the other parties, I looked, and in fact, we did not raise that. So I wanted to correct that and apologize for my misremembering. But as we discussed, it has not been something that was carried through by the appellee, and for reasons described in footnote 2 of our reply brief, I think that the issue is fairly encompassed within the issues that we did raise in the district court. And I would refer the court particularly to the decision in Harmon Industries about the scope of what an appellant is permitted to argue. So that was the first thing. The second thing is I wanted to come back to Judge Edwards' question about what the decretal provision should look like. And I want to commend to the court the decision in a case, I may be mispronouncing the name, Barreau against the Embassy of the Republic of Zambia, which was a decision from 2015. Actually, Judge Rogers was the author of that decision. And in the final paragraph, the court held that service had not been effected correctly. And the court wrote, "We remand the case for the district court to afford Barreau, proceeding in form of pauperis, the opportunity to effect service," and then it went on to give a little bit of guidance. And I think that would be perfectly appropriate for the court to do in this case. We're not asking for the case to be dismissed. It can be remanded. The case should be reversed. The judgment should be reversed, and the case can be remanded for the district court with instructions to exercise its discretion to permit the plaintiff the opportunity to effect service in accordance with the convention. That's the second thing. I hope that's helpful to the court. The third thing is I wanted to be really clear about diplomatic service. Both the convention and the Foreign Sovereign Immunities Act make diplomatic service purely an act of the State Department itself. There's no acceptance needed by the receiving state. Diplomatic service is complete upon acts by the United States Department of State. There was a proposal in the Foreign Sovereign Immunities Act to condition service on acceptance by the receiving state, and that was rejected by Congress.
Let me ask you what that means as a practical matter. Suppose the Department of State receives these papers in the proper office, et cetera, and Venezuela refuses whatever it normally should do to acknowledge diplomatic service. Are you suggesting then the State Department somehow becomes subject to the judgment?
No, not at all.
Yes.
So what mechanically what happens is the State Department delivers the papers through diplomatic channels to the recognized authorities. The State Department, without waiting for anything to come back from Venezuela or any other foreign sovereign, delivers to the plaintiff a certification that it has effected service through diplomatic channels. That's a letter.
Just so I'm clear,
It's
serve it on the Attorney General, or they serve it on anybody the department chooses, an official in Venezuela?
In this case, because of the limited nature of the Guaido administration, they are effecting service at this time on, I believe, on recognized diplomats sent by President Guaido. But it's not who receives service, whether that complies with the internal law of Venezuela, is not germane to the issue of proper service. If the United States Department of State issues a certification, and I see Mr. Yellen nodding, so that gives me comfort that I'm getting it right here. If the United States Department of State issues a certification to the plaintiff saying, we, the United States Department of State, have effected service through diplomatic channels, that's the end of it. Service has been effected, and the court now
under the Foreign Service Immunity Act, that's the end of it, and the plaintiff can proceed.
Correct. And that's also under Article 9 of the Hague Convention. The same result obtains under Article 9 of the Hague Convention. But in both cases, I mean, in the interest of transparency, I wanted the plaintiff to understand what we viewed as the correct interpretation of the law. But my client has no discretion to reject State Department service or to say we don't recognize it or anything like that. I mean, they can say that, but it wouldn't be binding in court. I was simply trying to be transparent with the plaintiff about what we were doing. And in fact, in other cases where the United States Department of State has effected diplomatic service, there's not been an issue. We've not challenged it, we've not criticized it, we've not complained about it, and the courts have gone on to enter judgments on behalf of those plaintiffs. Okay, I think.
So just follow through just a moment.
Sure.
So no discretion not to accept service, however affected by the Department of State in response to Saint-Gobain's request.
Correct. The State Department controls that. I'm sorry.
Yes, and then Saint-Gobain's motion for enforcement would remain before the district court?
That is my recommendation. The court this court has discretion to reverse and remand and give Saint-Gobain the opportunity to effect service correctly. Those were the only things that I wanted to clarify. I think the court has our argument. If there are other questions about those or other matters, I'm glad to answer them.
And the Department of State has no discretion to reject or to require exhaustion or anything like that?
Yeah, I don't know the answer to that as a legal matter. I can tell you as a practical matter, the Department of State has been forwarding these requests in due course. And I don't think I'm speaking out of school to say that it's not just Venezuela. There are other countries where there has been, for whatever reason, a breakdown in sort of the routine procedures that work well in the ordinary case. Even countries where there are no diplomatic relations, and the State Department seems to find a way to effect service, sometimes through intermediaries, and that's up to them. And if there's some diplomatic reason why they wouldn't do it, I would think the court, would take that into account. But we haven't seen any problem with that in Venezuela or in the case law for many, many years. I think in the early 1980s there was a problem with Iran, but that got sorted. And so I understand that the court might be worried about what happens if the fail-safe fails, but I think the thesis of the drafters of the convention and the thesis of Congress in the Foreign Sovereign Immunities Act is that the fail-safe is the executive in its conduct of foreign affairs, and so we would expect the courts to be comfortable relying on the executive in that constitutionally allocated domain.
Any further questions? Thank you very much, counsel.
Thank you,
Well,
Judge.
counsel, we will thank you and take the case under advisement.
Judy, can I have 5 minutes?
Yes, take a break.
Yep.
All right. And
This honorable court will now take a 5-minute recess. I am starting the recording again and letting IT know we can begin to broadcast again. I am asking the attorneys to start their videos and to unmute. Perfect. This honorable court is again in session. Case number 21-5081, Campaign Legal Center and Catherine Hinckley Kelly, appellants, versus Federal Election Commission et al. Ms. Malloy for the appellants, Ms. Branch for the appellees.
Morning, counsel.
Good morning.
Counsel for appellant, you may proceed.
Thank you. Good morning, Your Honors, and may it please the court. My name is Tara Malloy for Plaintiffs Appellants Campaign Legal Center, or CLC, and Ms. Hinckley Kelly. Thank you. The key issue on appeal is whether plaintiffs have been deprived of statutorily required information about potentially millions of dollars of contributions made by the Super PAC Correct the Record to the 2016 presidential campaign of Hillary Clinton, such that plaintiffs have suffered informational injury. The answer is yes. Neither Correct the Record nor the Clinton campaign reported a single in-kind contribution arising from this alleged coordinated spending, even though the Federal Election Campaign Act, or FECA, clearly requires this disclosure. Without this information, plaintiffs are in the dark about even how much money the Clinton campaign received and spent in the election.
So let me ask you a question which will help me to understand how you're focusing your argument. You have Wertheimer on the books, and my understanding of your argument is that in Wertheimer, the coordinated in-kind expenses were disaggregated. And the only question there was whether those expenses, which were disaggregated and shown, had to be shown by another group. I don't remember which, but in any event, they were already disclosed, and the court simply said they don't have to be disclosed again. Is that your argument? There was disaggregation already?
That's correct. This court in Wertheimer found that the political parties at issue already were required to report their coordinated expenditures as so-called Section 441 AD coordinated expenditures. So as a matter of law, these coordinated expenditures were disclosed. And at this point,
so you had a disaggregation between exempt and non-exempt expenditures.
Right, between coordinated and non-coordinated expenditures, exactly. This was already required by law from the parties at issue. And what the plaintiffs, the Wertheimer plaintiffs, were looking for was a reciprocal complementary report from the candidate that benefited from those coordinated expenditures. This was a duplication. That
no, I understand. I just want to make sure what your premise was, how you're reading Wertheimer, and that's what I thought you were saying. You were saying you can't possibly see that as relevant here because there isn't any disaggregation here, and so it's not a matter of duplicate exposure here. There's no exposure is what your argument is. Is that right?
Absolutely. And Wertheimer would only be on all fours with this case if, in fact, Correct the Record had reported all the in-kind contributions we allege occurred. And then we asked, well, we want the Clinton campaign
to
also report the same expenditures in their own reports.
All right, I understand your argument.
Correct. And to your questions about what was or was not in Correct the Record's reports, these are the reports it actually did file in the 2016 election cycle. These are the reports that purported only to disclose the entirely independent spending by a hybrid super PAC. These don't really supply any of the information that plaintiffs are seeking. In fact, Correct the Record contends throughout this litigation that it made no coordinated expenditures within the meaning of FECA, that any disbursement it made in concert, let's say, with the campaign qualified for the internet exemption. And this was the carve-out that the FEC created from its coordination rules for certain types of unpaid internet communications. But the plaintiffs contend, and the FEC's own general counsel agreed, that there was reason to believe that Correct the Record, in fact, made millions of dollars of coordinated expenditures that were not for exempt internet communications at all.
Well, that's the fight.
That's one of the fights, yes.
That's one of the fights. I mean, and the fact that there is a legal query here, it seems to me, of no moment, because as in Aikens and as in Shays, the court, obviously there's a legal question that's going to be answered, but I want to make sure I'm understanding. You're saying that in your view, they are listing things as exempt that are not really exempt.
Correct.
And there are consequences for doing it that way because there are penalties that might flow if you put things in the right category. So it's not, you're saying their argument that all you do is shift the columns is wrong because there's a consequence as to whether or not you're in the exempt or non-exempt category and whether you've done it correctly.
Absolutely. You cannot just shift information from one column to another because the information as it stands right now is incorrect. It is not an accurate portrayal of what plaintiffs believe under our reading of the law occurred in terms of correct the record spending. There's correct the record, as the FEC's general counsel found, tended to report all of its expenditures as sort of undifferentiated disbursements for general overhead, things like salary, rent, travel. It made no distinction between those disbursements that supported exempt internet communications and those disbursements that supported non-exempt, non-internet purposes. And in fact, some of these disbursements were probably needed to be allocated between exempt and non-exempt purposes. Then there's a whole other category of spending that even interveners don't contend were connected to the internet. This is things like campaign surrogate training or outreach to the conventional offline press. Here, as talked about the second fight, there is some question about which of these specific expenditures were coordinated within the meaning of FICA with the campaign. That means it has to be in consultation concert for at the request or suggestion of the campaign. There is a fight about which of these offline expenditures were indeed coordinated with the campaign. So we don't have information from Correct the Record's current reports about either of these possible sources of in-kind contributions from Correct the Record to the Clinton campaign. We just have reason to believe, and FTC's general counsel agreed, that there are possibly millions of dollars of contributions that went unaccounted for.
Ms. Malloy, assume for the sake of argument that I take your factual premise to be correct, that Correct the Record and the Hillary for America campaign violated any number of campaign finance laws. How does that hurt your client in a way that distinguishes your client from every other voter?
Correct. If I understand you correctly, you're asking whether the injury here was sufficiently individualized to confer
Correct.
standing.
Yes.
Right. And this particular specific issue was taken up by the Supreme Court in FEC v. Aikens. There, the plaintiffs again said, we don't have disclosure about AIPAC's spending. They didn't register as a political committee. One of the arguments made by the FEC said that, look, as a complainant here, you are on the same level with all the other public voters. What makes it individualized? And there the court found that the injury was still sufficiently concrete and particularized because there was information lacking. It wasn't an abstract concern about well-being. Instead, the complainants there had suffered informational injury because they didn't have FICA-required information. So that was sort of asked and answered in Aikens, that here the lack of information is sufficiently concrete that a complainant and each member of the public really has that injury.
I'll ask.
Go ahead.
No, please go ahead.
No, go ahead.
I'll ask Ms. Branch if she has a way to distinguish this case from Aikens. Imagine that she has a way to distinguish it that convinces me that Aikens does not control. Give me another way that you can win.
Another way we can win, yes.
Another way that you can show
Aikens'
standing that is sufficiently individualized.
That it's sufficiently individualized because the informational deprivation is concrete. The Aikens court also noted, and I think this was actually the DC Circuit in the preceding decision, that the actual complainants here were different from the public in that they'd actually already undertaken the entire FEC enforcement process. They were the ones that filed the complaint. They were the ones that alleged a disclosure violation. They were the ones that invoked the judicial review provision under FICA to get a review of the dismissal of the complaint. So they were separate from the rest of the public in the sense that they had undertaken this FEC enforcement proceeding. Further,
that's not enough to create your standing.
The test applied by this circuit is, one, whether a statute requires information to be publicly disclosed on the plaintiff's reading of the statute, and two, whether the information is of use to the plaintiffs. That's what is this test.
Of use to the plaintiffs has been more than what any voter might be interested in knowing. The cases
Correct.
have been where there's a mission, there's a obligation above and beyond.
That's right. And they,
You gather information and, you know, share it as you decide.
right. And that was sort of the second half of the informational injury inquiry. It was just less disputed, but CLC submitted an affidavit from one of its federal reform directors articulating and enumerating all the different ways that CLC as a campaign finance and democracy organization use, say, super PAC reporting to inform the public, to inform voters of the spending and the nature of their roles in elections. Further, Ms. Hilton Kelly submitted her own affidavit discussing how she uses this specific information in this case to evaluate candidates and engage in the political process. So absolutely, that was another prong that we showed with affidavits submitted below.
I mean, you're relying on Aikens and Shays is a very strong follow-up to Aikens saying, essentially, I think, essentially the same thing, that you suffer an injury in fact, if there's an inability to obtain information, and in APAC, it was the list of AIPC donors, that's all, and campaign-related contributions and expenditures that on the plaintiff's view of the law, the statute required be made public. And the injury in fact, there is an injury in fact when the plaintiff fails to obtain the information which must be publicly disclosed pursuant to statute. It's the information injury, it's different. The generalized grievance cases, my colleagues are alluding to, I think raise different issues than the information injury cases. And there is the additional problem with Wertheimer. Wertheimer is simply not on point because the information there was the same kind of information that's being fought over here, but it was disaggregated. So the information the plaintiffs wanted there here. Wertheimer is really about, you already have it, we're not going to let you get it again. So that case to me seemed irrelevant. And I don't know how you get past, and I'll be interested to hear the other side's arguments, I don't know how you get past Aikens and Shays. They are very strong statements about informational injury supporting standing.
We agree.
I suspect you did. I would be shocked if you had said I don't agree.
If there's nothing further, I can just reserve any time for rebuttal.
All right. So counsel for appellees.
Good afternoon, Your Honors. Aria Branch on behalf of appellees Correct the Record and Hillary for America. I want to start with where the discussion left off with the discussion of Wertheimer, which I do think is controlling in this case. The difference between this case and the Aikens case that's been referenced is that here, as in Wertheimer, the full facts are known.
No, they're not, counsel. I really want you to understand and respond to my concern. I spent a lot of time trying to sort this out. The information they want, disaggregation, to be able to determine exempt versus non-exempt, and something like that a group like theirs would surely be interested in, was exposed in Wertheimer. It is not exposed here. It is not merely the same information, a duplicate of the same information. It's a different array of information, and it has consequences depending what that array should. There's a big fight going on here, and that was shown in the agency proceedings over what should and should not be exempt. It's a huge fight, and that's what's motivating this litigation. They want the disaggregation to be able to suggest that when you disaggregate and you see what they're calling stuff that is fit for the internet exemption, it's nonsense. And their view of the law is what we have to accept to determine. You don't dispute that, right? It's their view of the law. And the fact
I don't dispute that at all, Your Honor.
Okay. All right.
I don't dispute that at all. And I'd like to focus then on what exactly their view of the internet exemption is here, because I think that's really, really important. Counsel said previously that there are certain expenditures like salary, rent, and other overhead expenses that they want to be allocated between exempt and non-exempt based on whether they fall within the internet exemption or not. That simply is not consistent with their view of the law on the merits. This is a manufactured argument that they've created to create standing. On the merits, their argument is that no overhead expenses, whether it's for salary, rent, etc., would fall within the internet exemption. They would always be coordinated. Their argument is that correct?
I want to stay with you and raise my concerns. You make that argument in the brief, and I understand the argument you make. And respectfully, I think you're overstating their position, because they have a long argument on mixed expenses, on categories where there may be, and I understood what they were arguing. I certainly never took them to say that everything in the disputed list is in this category that is being fought over, this exempt category or non-exempt category. I don't read them that way. I think they give a couple of examples. That salary, for example, where it might be partially exempt, it might not be. It might be exempt, it might not be exempt. And they said they do not mean to say that all of these disputed expenses should be characterized one way. That seems very clear to me in their argument.
I'd like to point you, Your Honor, in response to that question, to some of the statements they've made in their briefing, which I think directly contradict that position that they take on standing. In their opposition to our motion to dismiss in the district court, they said, quote, disbursements for staff salaries amounted to compensation for personal services rendered to the campaign and were therefore in-kind contributions, whether or not the ultimate activity qualified as a public communication. The same goes for what Campaign Legal Center.
I'm not sure what that is showing.
Their position.
There are a couple of questions: coordinated expenses, and that's by definition. And then within that category, there's exempt and non-exempt with reference to the internet. So a coordinated expense has to be found to be a coordinated expense. And they're saying, yes, they're saying a lot of these things are just coordinated expenses. And then in addition, some are being taken as exempt when they should not have been taken as exempt. So I don't see how their position is inconsistent.
Respectfully, I think their argument is that none of the expenses for overhead, for salary, rent, etc., fall within the internet exemption.
No,
so they say Correct the Record acted in full coordination with the Hillary Clinton campaign, and that only expenditures related directly and exclusively for internet communications would fall within the exemption.
That is certainly their argument with respect to the internet exemption. That's right. But I'm not sure how that's damning. There's still
the reason that's damning is because all of Correct the Record's expenditures that are directly and exclusively related to unpaid internet activity is already apparent on the face of their reports.
Yeah, and
so if you go
but
on the FEC,
but you ignored the references that I'm giving you. I didn't give you the page numbers. They can fill in wherever they want. They're saying there are mixed expenses in the categories that we're talking. They make it very clear there can be mixed expenses. They are not saying this whole list is the same and everything in it should be, they're characterizing as exempt. That is not the way I read their brief.
So I think, respectfully, Your Honor, the mixed purpose expenses, such as for video consulting and travel, communication consulting and travel, those are two examples that they give in their briefing. Those types of expenses are paid overhead expenses that they say would never fall within the internet exemption. So they would never need to be disaggregated under their view of the law, which, as you said, is what controls under Aikens. The Correct the Record's expenditures that would fall within the internet exemption, according to their theory, are already apparent on the face of the report.
Not if you have mixed, you agree with me, not if they're really, if I'm right in reading their complaint, not if they are saying there are mixed expenses and we do not mean to characterize them all the same way. If that's correct, then my concern about your position is correct, right? Because that information was disaggregated in Wertheim. It's not disaggregated here.
I think even if that were the case, as the district court's opinion points out, that ultimately wouldn't matter. I think the classification of a certain portion of an expenditure as an in-kind contribution is still a legal determination.
Oh, no,
not
wait.
an
I
inquiry for additional
wanted to get
facts.
to this. So what? Aiken starts with saying there's a legal determination we're making. This political committee is or is not a political committee. You got to have a legal determination in there. That doesn't dispose of the case. What's really going on in Wertheimer is the court, there's loose language, but the court is fundamentally saying the materials disaggregated have already been exposed to the plaintiffs, and they just want them exposed by someone else. And we're not going to indulge that. There's no injury. They already have what they want. You don't have disaggregation here. And you can't say merely because this fight involves a legal question. APEC involved, Aiken's involved a legal question, as did Shays. How the court go ahead.
All of the cases involve a legal question, but the difference between APAC and this case, Your Honor, is that in APAC, there were actually facts that were hidden, that weren't disclosed, right? There was an entity that wasn't publicly reporting. Here, correct the record.
They came in and said, you can't characterize this as a non-political committee. And why does that matter? Well, if you view them as a political committee, we get to see who the donors are and how much they donated. Well, that's the information they don't have now, okay? And so in this case, they're saying, if you don't disaggregate, we have no idea what your claims are honestly made with respect to exempt and non-exempt and in-kind reporting requirements. And those were a matter of law.
I think that this is a convenient kind of argument that they've manufactured to create standing. I think allowing the appellants to turn one fact, which is not knowing how much of a particular expense is coordinated, into the magic fact that would always prove an informational injury, would mean that any plaintiff could prove an informational injury. Any plaintiff could come to court and say, I want to know whether $100 of a particular expense was coordinated.
Would that argument have prevailed in Aikens?
I think so, Your Honor, because in Aikens,
other people can make the same complaint and so nobody can?
Well, I think
that wouldn't have prevailed in Aikens. Supreme Court wouldn't have bought that. We wouldn't have bought that in Shays.
I think in those cases, it's just very different because you had an entity that was not already reporting its expenditures. Here, Campaign Legal Center knows the amount, the date, the recipient, and the purpose of every expenditure made by Correct the Record.
The problem is the agency's law and the statutes say that they have to report coordinated in kind, and they have to expose exempt, non-exempt figures. The statute and the law require that. They have to do that.
That's right. But those determinations are legal determinations, right? They are not determination.
It's the same thing in Aikens. It's a legal determination whether you're a political committee. Those political committees are saying we're not a political committee, so we don't have to submit this information. The Supreme Court said that's nonsense. Their view of the law is what controls, and if they're correct in the view of the law, then you're covered and you have to expose the information.
I think the distinction here is that appellant's view of the law is that the internet exemption is extremely narrow, and that the expenses that would be exempt under the internet exemption are already clear on the face of Correct the Records reports. If you go on the FEC's website, you can search for web hosting, you can search for graphic design. These are the types of expenditures that Campaign Legal Center says would not be coordinated. Everything else under their theory of this case would be coordinated. They say, and I quote, everything that Correct the Record does by its own admission is in full coordination with the Clinton campaign. Although Correct the Record claims it is relying on commission regulations accepting certain internet activities from the definition of coordinated communications, those rules are simply irrelevant.
If you disaggregate, you'd know the amounts of the coordinated contribution. Just like if you make a committee, a political committee, you would know who is contributing.
arguably there's no need to disaggregate because according to their theory of the law, it's all coordinated.
Well, yeah, no, that's where we disagree on what their argument is, but we'll, when they come back on rebuttal, I'll listen to what they have to say.
Ms. Branch, if I were writing an opinion finding for your side of this, finding that the plaintiff lacks standing, I'd go through the analysis under case and controversy, and I'd come to a paragraph where I say, Akins does not control because. And you've given me, I think, the half sentence that would follow, which is Akins does not control because there was no disclosure by an entity of its expenditures, and here there is. The next sentence needs to be, and that matters because. So can you fill in that blank for me?
Sure, Your Honor. Thank you for your question. And that matters because the determination of, the legal determination is not sufficient to create an informational injury. And so here, all that would be disclosed if Correct the Record had to go back and amend its reports, as counsel has pointed out, would be a legal determination. You would be moving certain expenses from one line of Correct the Record's reports to another line that shows or indicates that the expenditures were coordinated. And that type of legal determination under Wertheimer is simply not sufficient to support an informational injury.
I understand your argument.
The court, in response to, I'm curious as to how you're reading it, because I went back and read that a lot of times. I think all the court in Wertheimer said is the precise information, the disaggregated information in Wertheimer, which is what we're fussing over here, has already been exposed. It's already been released. And all they're asking for is that someone else released the same thing. And then the court goes on and states this language about, so all you'd end up with is a legal determination. As if that holding is weighty somehow. That is, if you end up with a legal determination, that can't support informational injury. That really makes no sense whatsoever, because in Shays and Akins and all the other informational injury cases, a legal determination always is forthcoming.
I think what the court has said is that where there's just a legal determination, that's not
just the legal determination. Yes.
Right. That there have to be accompanying facts that would result as a result of
disaggregated information is not additional information.
So I would point your honor to the Crew v. FEC case, which we've cited in our briefing and which Judge Boasberg relied on below. And the site for that is 799 F Sup 2nd.
That's a district court case, right?
It is a district court case, Your Honor.
Respectfully, that's not going to carry weight with me. We're talking about a legal question here, and we're talking about which precedent applies.
Sure.
And I'm much interested in what, in all due respect, in what a district court judge says about that question.
Understood. The only reason I was going to point it out is just because in that case, the court actually looks at the precise issue that I think is present here, which is how much of a particular expenditure should be considered a contribution and how much would not be considered a contribution. And that court did find that was just a legal determination on sort of a micro level than what.
And if I'm looking at Shays and Akins, that makes no sense to me, because there are consequences that flow. And those who are interested in this information, like this group, there's no doubt that they have a very serious interest in this information. You're not contesting that. It's not just someone off the street. This is what they do. They're concerned about this. It matters a whole lot whether and how you disaggregate. Because if the disaggregation shows certain numbers over the limits, then there's a question as to whether there was some illegality.
Well, here, I think Correct the Record has come to court to get the law enforced against I'm sorry, Campaign Legal Center has come to court to get the law enforced against Correct the Record. There's no, I mean, they're a complete argument. If you look at the administrative complaint that spurred this case, is that everything Correct the Record did was in coordination with the Hillary for America campaign. They simply want the FEC to apply the coordination rules to Correct the Record to punish it. And this court has said time and time again that that is not sufficient for informational injury, that just trying to get the bad guys is not enough.
That's all that was going on in Aikens and Shays. The plaintiffs there came in and said, this is information we're entitled to, and we're going after these committees. They're political committees. We're going after them because they have information we are entitled to under the law. Same thing in Shays, exactly the same thing. We're going after them, and we're going to use the information. We're going after them because they're withholding information we're entitled to have.
I think the difference in those cases is that there was factual information that would have been revealed from the legal finding of coordination that is just simply not present here.
Do you agree with me at all, then, that the disaggregated information, if it's disaggregated, do you agree that that is separate information?
So I would not agree with that, but I think the most important piece of this is to really zero in on Campaign Legal Center's view of the law and how it applies to this case.
Of course, we view in on their view of the law. That's what we have to do in an information standing case.
Exactly, and I think that
we have to accept their view of the law.
Right. And their view of the internet of the law here is one, that everything Correct the Record did was in coordination with the campaign. And two, that the internet exemption is exceedingly narrow, such that it would never exempt any of the expenses that they provide as examples. David Brock's salary, for instance, would never fall within the internet exemption. It would never not be coordinated under their theory of the law. It would simply move from one line as an operating expenditure to another line because
it would show different information because it would be disaggregated. And the view of the law thing just makes no sense to me, because in Aikens, that's the whole fight. Why I am, as a committee, do I have to expose that? Because the plaintiffs here think the view of the law is you're a political committee. So the fact that we're going to give them a legal ruling in their favor and accept their view of the law, so what? It's a really unfortunate piece of language in Wertheimer, but it is certainly not the controlling consideration. Wertheimer is about double exposure. Wertheimer is about the court saying they already got the information disaggregated, which is exactly what these folks are looking for, disaggregated information. And Wertheimer,
I would argue that this case is on all fours with Wertheimer because they already, under their view of the law, disaggregated information would change absolutely nothing here. Because salary doesn't need to be disaggregated. Expenses made for consulting and various paid activities never need to be disaggregated under their view of the law.
It's not like their view of the law is untenable, which we don't have to decide, because the general counsel of the agency was reaching a view that was consistent with their position. That is, the contributions here was subject to a different picture than the one being painted by the group. That's exactly what the general counsel was saying. And then those who dissented in the agency responded by saying, no, everything is okay. So, I mean,
right. And I know that's not an issue here.
There's a clear fight that is here. I don't have any view one way or the other, but I know they have a tenable view of the law. It's not an inappropriate view of the law. And I'm supposed to accept that to determine whether there's more information that they are entitled to because the law says they are.
I totally understand that. And I agree that's, not yet at issue in this case. We obviously disagree with their view of the law, but I do think that it's relevant for the standing inquiry. And for the standing inquiry, the types of expenditures that they have identified that would be disaggregated is simply just not the case. They wouldn't be disaggregated if there's a finding of coordination. Under their view of the law, they would simply be deemed coordinated. They would be moved to another line of the FEC report. and there would be law enforcement consequences that would follow. There simply just isn't additional information they would learn because frankly, of their view of the internet exemption, which is exceedingly narrow and really applies to direct costs, not including overhead for salary, travel, or rent. Those expenditures would never be disaggregated under their view. So I do think this case is on all fours with Wertheimer. And I think,
Oh, it's not on all fours with Wertheimer if you had disaggregation. You're not raising the same issue. You can't say it's on all fours with Wertheimer. You can fight about what Akins means. It's not on all fours with Wertheimer if you had disaggregation in that case. You can't possibly say that. You had a request for more a duplicate production of information. That's all.
I think here you would have that same request, because part of what they want is for the Hillary for America campaign to report the coordinated expenditures that they contend would arise.
Gotcha. Thank you.
Thank you, Your Honor.
Thank you.
Anything further, counsel? Counsel for appellees?
Hello, yes, I would just like, for the record, to reiterate that it's plaintiff's view of the law that governs a standing inquiry, and surely it's plaintiff's view of its own understanding of the law that should govern our merits inquiry. At no point has Campaign Legal Center or plaintiffs claimed that all of Correct the Record's internet-related spending was somehow not exempt. You cannot read the two opposing district court decisions, all of which focused on how to tease apart overhead expenditures to mean.
I thought counsel was referring to your administrative complaint and filings.
Also not that. I would just suggest that if you wish to read a couple pages from our motion to dismiss opposition, we specifically were the ones that raised both David Brock's salary and $589,000 in travel expenditures, and argued that they would need to be allocated between the exempt internet and non-exempt non-internet purposes that they supported. There's no way to read this. We were the ones who raised the salary and travel and other disbursements for overhead as needing to be allocated. And that was the reason that the district court reviewed exactly this question of how to separate what appeared to be a undifferentiated independent disbursement for overhead into its constituent parts, which might be some amount for independent spending and some amount that actually constituted the in-kind contribution, because that was a coordinated expenditure with the campaign. I don't know what we in the district court would have been doing if indeed all of Correct the Record's expenditures were not exempt. This was exactly both standing and the merits inquiry that both took as their starting point the assumption that a sophisticated opposition research group like Correct the Record had a very large online presence and ran a very sophisticated website, and all of the expenses relating to that operation, the online portion, were going to be exempt and therefore not considered a in-kind contribution to the campaign.
You think they did anything that was not in coordination with the campaign?
Meaning, when we get beyond the legal question of the internet exemption into the area where no party contends that there was a nexus with the internet, this might include the surrogate training and the outreach, the rapid response outreach to the press. Well, there it's contested. There was some categories.
I'm not asking what they contest. I'm asking what you think. Do you think everything they did was in coordination with the campaign?
We think there's reason to believe that some amount of their non-internet spending was coordinated with the campaign. As we've said, we're relying upon reputable news articles and the statements, sort of general statements by their leadership and representatives that they coordinated with the campaign system.
When you say some amount, do you mean all of it or not all of it?
Well, without a FEC investigation, we don't know. That is information that we don't know. And in fact, the general counsel found the same principle. They said it's clear that there's been some coordination between Correct the Record, systemic coordination between Correct the Record and the Clinton campaign. However, even the general counsel, in making its recommendation, said we do not know the extent to which the non-exempt, non-internet spending was coordinated within the meaning of FECA. And we submitted that the general counsel doesn't know, that we cannot be expected to know simply from the public news reporting, which was reputable, but hardly specific or complete.
So in addition to news reporting. What else did you say you had?
We had the news reporting, and then in addition, the leadership of Correct the Record, for instance, David Brock, made multiple statements to the press that they were under the thumb of the campaign, that they were allowed to coordinate because they engaged in exempt spending, and so on and so forth. So we relied upon both the public statements of the entity and these press releases. And again, not press releases, sorry, press reports. And again, at least the Office of General Counsel agreed with us that there was reason to believe at least that some amount of the non-exempt, non-internet spending was coordinated within the meaning of FICA.
I mean, your focus really is on the exemption. If I'm hearing you correctly, it's neither here nor there if the other side says, well, you assumed all of this was coordinated. If I'm hearing you correctly, you're saying maybe it was, maybe it wasn't. The point is not all of it was subject to the exemption. And that's what we can't see.
Correct. There's two lines of inquiry. One, how broadly to apply the exemption, and two, where we're talking about uncontested, non-exempt spending, what in fact was coordinated within the meaning of FICA. If you have nothing further or no further questions, and
I want to be clear about one other thing. So here, you're relying on the regulations at 100.8A and 100.7A13. Is that right? Or 100.23.
we are relying upon the statutory reporting requirements. And then those.
No, that's USC 431, 8A1 and 9A1. All right. And that talks about generally. All right. But then the regulations are more specific in talking about in-kind contributions and coordinated contributions. That's what I'm trying to just throw in on here.
Right. I would direct the court's attention to two statutory provisions. One, 52 USC 301(16)A7.
Okay, hold on. Hold on. I'll write this down. 52 USC. Yeah.
30116A7B little I. This defines what a coordinated expenditure is. It says an expenditure made in cooperation, consultation, or concert with.
Right.
And then it says these are contributions to such candidates.
Right.
So that is the provision that delineates what a coordinated expenditure is and how it's treated as a contribution. Then the various provisions of 52 USC 30104B state with great specificity the reporting requirements for a committee. And among the reporting requirements are these itemized information about date, amount, purpose, etc. So these are the two provisions of statute that apply. Now, the internet exemption was something that was entirely a regulatory carve out.
No, right.
So those are the two kind of operating areas of law. And we did not challenge the internet exemption, which is a number of regulations, as contrary to FICA in and of itself. We did say as a APA challenge to the construction given to the regulations by the controlling commissioners that dismissed our complaint. But the court below found that the APA claim was basically coextensive with our FICA claim and dismissed it on that basis.
Anything further?
Nothing further from appellants.
Thank you. We'll take the case under advisement.
This honorable court is now adjourned until Wednesday, November 17th at 9:30 a.m.